Welcome to NeLI Pod, the official podcast of the National eDiscovery Leadership Institute. Hi, I'm Daniel Gold, your co-host and navigator through the evolving landscape of eDiscovery.
And my name is Brandon Mack. I'm the co-host of our podcast. Our guests, from judges to eDiscovery professionals, share insights that cater to all experience levels.
Whether you're looking for a broad overview or in-depth technical analysis, this podcast is your gateway to understanding and implementing effective eDiscovery practices.
It's important to note the opinions expressed on this podcast are those of the individual guests and the host, and do not necessarily represent the views of their respective employers.
We're here because of our passion for eDiscovery and our commitment to providing free, accessible educational content to legal professionals everywhere. And welcome to the NeLI Pod, where we explore the intersection of law, technology, and practical discovery solutions. I'm Daniel Gold, here with my co-host, Brandon Mack. Today, we are diving into probably one of the most critical conversations in our field right now, AI, ethics, and also the future of what is going to happen with discovery. We're doing that with Robert Keeling, partner at Redgrave. Robert brings a rare combination of philosophical depth and also practical experience, having led large-scale discovery matters, including DOJ, FTC second requests, and all of that while challenging our industry's assumptions about technology's role in legal practice. One of the most interesting things that I've read that Robert has done is an article called Humans Against the Machines. And also, Brandon, I know you like this one, Document and Review, You're Doing It Wrong, along with contributions to the Sedona Conference, Generative AI, and Discovery Primer. And really, Robert has established himself as a leading voice on validation, defensibility, and most importantly, the irreplaceable value of human judgment in an increasingly automated world. Robert, welcome to the NeLI Pod. We are so glad to have you here.
Thank you for having me. Really appreciate it. I'm looking forward to the opportunity to talk with you today.
Perfect. Robert, I want to start off. I just mentioned Humans Against the Machines. That was published in volume 26, issue 3 of the Richmond Journal of Law and Technology, 2020, so 5 years ago. And you argued for the enduring value of human judgment in review. And that was fascinating reading that 5 years ago. So here we are in this Gen AI wave. Has your thinking shifted? And if so, where? And maybe it hasn't at all.
So I would say it's evolved. I don't know if shifted, but essentially what we were looking at 5 years ago is there was kind of broad calls that at the time TAR, technology assisted review, based off various machine learning algorithms, was replacing kind of human review. And what we did is we kind of challenged that basically and looked at our actual matters. Because it's one thing to do a bunch of testing on, people are still testing on the Enron data set decades later, but to test on self-contained data sets. But in my practice, I'm working with clients every day on real legal matters, litigations, second requests, CID responses, and the like. And we're employing technology in all of those. But what we're seeing is the limits of that technology, and then necessarily how I think it was Elon Musk observed at one point that I think the quote was something like humans are underrated, or it turns out humans are underrated, that you will be surprised about all the ways that technology, even advanced as it is with Gen AI, has its limits. And so the question isn't whether attorneys are going to be replaced or not, but the question is how attorneys can leverage this technology going forward.
Robert, in those years, as I've been reading things that you've written and listening to you talk about the use of technology in discovery, specifically, a lot of it's been around TAR, and now there are a lot of corollaries being drawn between what we learned as we moved into the world of TAR and now what we're doing as we move into the world of Gen AI. A couple of the concepts that you have continually talked about are validation of your process and the defensibility of the process. for attorneys who are out there listening to this podcast who don't necessarily have the depth of experience that you do with these tools, when you think about Gen AI, what does the appropriate Gen AI validation plan look like with what we have today? What types of sampling and metrics should we be tracking? Are there certain types of documentation that you can already see are going to be necessary or very useful in a world using Gen AI for different e-discovery tasks?
Yeah, again, it's a great question. So what I would advise for people who don't kind of who are coming to this now is that you really need to, when it comes to defensibility of process and validation with Gen AI, you really need to separate it into um, outward-facing uses of Gen AI versus inward-facing uses of Gen AI. And what do I mean by that? By outward-facing, I mean using Gen AI to identify responsive documents, but more importantly, to identify non-responsive documents. And so that even if uh, a document set is otherwise within scope, let's say it fits the negotiated time frame and custodians and the like, that you're using Gen AI to say, hey, look, 99% of these docs are not responsive to these doc requests. And so they're not going to be in the review population and they're going to be excluded from here on out. Um, as with maybe, yeah, I think that's the primary outward facing. There's a few others, but that's the primary one. And for that, when you're really leveraging the technology to say, hey, look, there are documents that maybe hit on agreed upon search terms, but uh, we're not going to have a human look at them because the Gen AI is saying that they're non-responsive, and we have a lot of confidence in that call because of the processes that we use to get there. Um, and and so there, I do think defensibility and validation are very important and should be considered as far as documentation and the approach that you go. That said, I personally don't think that there's anything unique or special with Gen AI that calls for any unique or special validation protocols to be applied to it. In other words, the same validation that we've been using with respect to TAR, um, namely whether it's control sets or validation sampling, illusion sampling, basically using, and again, I just got into the weeds a little bit, but let's step back to use statistical sampling to show that Gen AI did what it was supposed to do. In other words, sampling on your responsive set, but more importantly, sampling on the set that Gen AI is saying is not responsive. And based off that sampling, being able to show statistically that your use of the Gen AI kind of satisfied kind of the reasonableness standard under the rules and was a reasonable approach to use in your matter and can be reliable and relied upon. Um, but again, there's nothing special about Gen AI in my view in that regard. But again, like you have to differentiate it though from the internal uses. And by internal uses, I mean things like, well, use Gen AI for issue coding or use it for key document identification or use it to identify privileged documents or to help, build your case, right? To find the evidence, to interrogate the data. You have various Gen AI chatbots that are being marketed at the moment. Like all those are internal facing. And for those, I rarely engage in any kind of statistically significant validation efforts. There's lots of times where I engage in no validation efforts for those. I just kind of look at the results and then see whether, it was kind of good enough, whether it worked. Um, and that's a very qualitative way of going about it than a quantitative way. But I don't think we need to build in a lot of quantification metrics or steps into your internal uses because that increased cost, it slows the process down. There's lots of times where we're just kind of running multiple prompts and just seeing which of those work and for lack of a better way to describe it. And so you kind of got to think about it from those two perspectives when you're leveraging Gen AI, but also other search methodologies like tar or search terms.
So building off of that, then at NeLI this year, prompt discoverability, I believe, sparked some debate both during a panel as well as afterward. And the question that came up really was, should the Gen AI prompts, let's say that you're doing, Robert, be used against you? In other words, can the plaintiff's bar say, hey, I want to collect all of the prompts that you put into the software because I want to know what you're doing. Did you bias, for instance, the Gen AI by asking specific questions in the way that it did? In other words, really what this comes down to is, should Gen AI be protected as attorney work product, or are they discoverable as part of the overall process? And where is, if at all, that ethical line?
Yes, with respect to prompts that using for kind of the outward facing to, for example, to identify responsive documents in connection with requesting party discovery requests. The prompt is clearly work product, and it's not even a close question.
So
Um,
wait, but back into that though. I mean, you
yeah,
say that very definitively, right? And with a lot of authority in your voice when you say that, but but why?
because it reflects the thoughts and mental impressions of counsel, including me, when I'm doing it, about the case, about both the claims and defenses of the case. It's really just classic opinion work product, right? It's not, it's similar to an interview memo of a likely trial witness. And the interview memo not only says what the witness kind of relayed, but gives the thoughts and impressions about the strengths of the witness's testimony, how they appear as a witness, whether they make a good witness on the stand, all of that. It's very similar to that. It's to me, it's a classic work product. And I would say from my only thing to say for the plaintiff's bar here is be careful what you wish for, because Gen AI is, I think, materially better for plaintiffs, so the use of Gen AI in many cases, if not most cases. In other words, they're likely to get more responsive documents and less false positives in the productions, potentially faster. And if they are trying to litigate for the prompts, I think all we need is one or two judges to rule that the prompt is discoverable, and you're going to significantly slow down and retard the progress and the use of Gen AI in discovery.
Interesting. I want to talk about something that's somewhat related, another privilege issue, and that's privilege logging and the use of Gen AI in generating privilege logs. I've heard you say that privilege logging is one of the toughest places to automate the e-discovery process, but I've also heard that you feel that it's one of the most promising areas for Gen AI because of the way that Gen AI works. The fact that it does summarize and generate information very well. In your opinion, with the tools that we have today, where do you think that Gen AI is safe to employ in the privilege logging effort? And where do you see just more danger than there is benefit in trying to use a Gen AI tool to help shortcut that, what is often a really time-intensive process of generating a privilege log?
That's a great question. So, in my view, the technology has advanced to the point where it is safe to use for logging, full stop. Um, we've been working on this problem, namely the use of Gen AI to create privilege log entries for about 2.5 years. And in that time, we've seen the really rapid progress of the technology to this problem. And it's a hard problem because not only do you need to describe the document without hallucinations, for example, but you need to, uh, under the rules, provide enough information about why the document is privileged or the redacted content is privileged without revealing the underlying privilege advice. So it's a very difficult problem, and it's a problem with that frankly a lot of human attorneys struggle with when creating priv log entries. But as I said, the technology's come a really long way, and in my view, it is um, ready to go right now to use in privilege logs and to create privilege log entries. That doesn't, I don't mean to say that necessarily it's a magic button. Typically, there is a fair amount of iteration that occurs on the data set, and the priv data set in particular, running it through and refining kind of the inputs and prompts and the like that go into it to make sure that the tool is appropriately creating log entries for that case. But it does get you there. Now, as far as weaknesses, it's also the weaknesses have been getting less. The main one is that the vast majority of the tools look at the four corners of the document and aren't looking at the family relationship. Again, there's lots of providers that are trying and working to solve that issue. Um, and so that and it tends to struggle with work product compilations because for the same reason, like a work product compilation, like a deposition prep binder, like the individual documents look like ordinary course business documents, right? It's just the collection of them and perhaps the parent document that makes clear that this is actually a dep prep binder and therefore appropriate for protection. But these are kind of edge cases, right? And can be solved by other methodologies and workflows. But it can get and can solve and accurately describe the vast majority, if not virtually, uh, uh, most of the privileged documents at issue. Now, that doesn't mean like most people don't. You still want like some sanity checking, and we talked about validation. Those are helpful, but it's really gotten to be an effective technology.
You handled some of the largest second requests that are out there. I'm curious if you could tell us what is the state of the state with respect to using Gen AI on second requests, and also are there any parts of a second request that you wouldn't trust Gen AI to?
That's a good question. Uh, I think the answer is no to that last question. Um, so we are using Gen AI for HSR responses. It's very well suited for that to try and find the most relevant documents to the transaction, kind of the business course materials related to the deal. Uh, it's also being used for privilege logging, typically with human in the loop methodologies. Uh, this isn't a merger matter, but in a case, we had submitted a Gen AI review protocol to one of the government agencies and just waiting to hear back from them. But we're affirmatively proposing the use and disclosing the use. It's a challenge right now, I think. It's just getting over the initial hump because in most deals you want to move fast,
Mhm.
and the easiest way to move fast in a merger review is to propose TAR 1.0 as your methodology because that has the least friction typically. Uh, I think most parties assume that a Gen AI protocol would involve more discussion with the agencies, more questions, more uncertainty. And so that raises kind of a question about whether to use it versus kind of tried and true strategies. So I think it's just getting kind of over that initial hump. If we had, for example, like a white paper or something from the DOJ or FTC encouraging the use of Gen AI for responsiveness reviews, I think that would go a long way. But, I think parties should definitely feel empowered to use it in merger reviews. I think it is effective and efficient if it was used.
Sorry, can I just ask a follow-up question on this? So it's interesting. So you said something that I wanted to go back to, which was it's easy just to use TAR 1.0,
Right.
right? But I think it's interesting that you say, well, it's just easy to use TAR 1.0, but we're skipping over, and we have skipped over this idea of continuous active learning as potentially an acceptable protocol, the way that you phrased it, but that we're hopeful that Gen AI will be acceptable. Do you find that curious at all that we could, you know, we're good on the old antiquated TAR 1.0 methodology because it's tried and true, but Gen AI will be fine, but we skipped over Cal.
Right. So we have experience in certain deals with the agencies accepting Cal, but it is not the preferred methodology. I will say I'm a little bit on an island here, me and maybe one or two other people, in the sense that in the context of merger reviews, I prefer 1.0 compared to 2.0. I frankly, I generally prefer 1.0 in most matters because the techniques that we use, we achieve much higher precision in a 1.0 approach as opposed to a continuous active learning approach. And it's one of these things that 10 years ago or 8 years ago, Cal was particularly useful because it accelerated your time to a given level of recall. That is less of a consideration now that the technology has matured. Typically, my clients most prefer efficiency, and efficiency is measured by precision, most of them. So anyway, that's a little bit of a tangent, but you are right. We may, as far as large scale adoption of what tools are used in the merger process, we have the potential to just kind of skip over 2.0 being broadly used and go right to Gen AI.
Robert, another topic that you've talked about that's related to what we've been discussing is you mentioned building a Gen AI plan or proposed plan to exchange with the government or with the other side. We've talked about discovery on discovery. With the advent and introduction of a lot of new technologies that people aren't necessarily very familiar with, TAR 2.0 being one of those, there's been a lot more discussion and motion practice around the use of these tools in courts. So when we talk about discovery on discovery, when we talk about the use of Gen AI as a new piece of technology, what do you think teams have to think about as far as documenting their process in order to avoid fights over the use of this new tech?
Yeah, so for me, I think it really ties into what I was talking about, that we typically, if we're going to be using it for responsiveness review, do enter into at least some kind of protocol or disclose a description of our process to the other side. And that, at least in our experience, tends to limit the disputes down the line because you're describing what the process will be before you're actually getting started with the process in substance. And it allows the other side to comment. That said, under Sedona and long-lasting principles, we as the producing party are best situated to kind of design the most appropriate process for producing documents in response to the request. So uh, we don't kind of think of the protocol as a way to the other side to necessarily dive into our process, and we typically do not allow that. But there's a lot of information that can be disclosed to have the other side be comfortable, including, for example, the provision of metrics, and other data that could be provided to them to show that the process worked as intended.
One of the areas I really want to dive into with you, I've heard some of the feedback from some judges and retired judges like Judge Grimm. I've gotten some interesting feedback on this question, and that is talking about what we're going to do about evidence authenticity. It, with all of the great things that we're talking about with Gen AI and being able to find and discover the truth, if you will, or the facts associated with the issues of law and the people that are important in the case, there's the other side of this, and I'm not going to call it a nefarious side, but it is the other side of this, and that's deep fakes and synthetic media. Under the federal rules of evidence, we talk about authenticity, different than we do in other contexts, of course. When we talk about like how do we authenticate evidence, and it used to be a little bit easier, I think, when somebody would take a photograph and you would have counselor to ask the witness on the stand to authenticate the photograph, the time, the place when it was taken, etc. It
Right.
was easier to authenticate with metadata with a digital camera. Now you can, Brandon and I have played with AI multiple different ways, and one of them is, I could create a receipt as simple as it sounds, but I can create a receipt that says that Brandon and I got coffee together at a coffee shop here in Kansas City,
Yeah,
and it has the last four digits of my corporate credit card,
right,
and it looks real,
right.
right? How do we authenticate this now?
I it's an incredibly difficult problem, and I'm unfortunately the problem is only going to get worse and harder as the technology continues to improve. I mean, we're now seeing if you're on social media, you can see how the Gen AI video is getting better. Almost in real time, you can see the progress of the technology where yeah, a year or two ago, it was very clunky and very obviously fake and kind of used more from a joking perspective. But now it, it's getting increasingly harder to tell what's real versus what's not. And, I think there's going to be a lot of corporate productions where it's not going to be a real issue because those productions are backward looking and you're collecting from kind of ordinary course files and sources. And so that the issue of deepfakes won't kind of enter into the calculus. But there's going to be lots of cases where it's going to be used and it's going to be front and center. I would expect. Um, so, with respect to social media broadly, you saw it was really kind of the family law courts taking the lead on the admissibility of social media and the authenticity of it. I would expect the same to be the case here, where you're going to see it's kind of like your divorces, child custody, where there might be very high incentives to create deep fakes. Also, employment law context, I think you're going to see that. Um, but who knows? Trade secret matters and the like. I do think you're going to start to see more and more of this kind of seep in, and kind of the what it means for the judicial system and frankly the administration of justice more broadly. I think it's going to be a very difficult problem.
And let me just add a quick follow-up on this. So the federal rules of evidence, in order to change the rules of evidence, so to speak, and to update it, if I'm not mistaken, Robert, that could take 3 to 5 years just to change the rules. By the time that actually happens, we are going to be who knows where AI will be in 3 to 5 years. So what does that even look like for us? I mean, it sort of sounds like the way you left the answer is that we're just really kind of left in limbo right now, and it's on a case by case basis until something really truly breaks, and then absent changing the rules, we're going to have case law to help us, I guess. I suppose is that your thinking as well?
Yes, it's a very hard problem for the rules process to address, right? And the rules committee, given kind of the structure of that process does take years typically. Right now, we have before the rules committee a proposed rule 707 relating to AI, although that it's not kind of it's not addressing deep fakes head on. It's it's more about um, compilations and the like being used for trial purposes, but it's not necessarily getting at the underlying authenticity issues. Um, but even that is controversial, right? And so it's hard to like come up with language that can really address deep fakes and to do it in real time as the technology is evolving on us in real time.
Yeah, Robert, I'd like to shift a little bit from talking about the technology to really talking about the practice. Um, you've made a move in your career, moving from big law to a more specialized boutique. And I've got a couple of questions about that. One, how does that form of an organization let you experiment more and discover more in using tools like AI? And then do you think that that is the direction or the future of where legal services goes or should go? Because as we start to integrate this technology more and we surrender more and more of the uh, what some people would call the menial tasks of law to Gen AI and other tools like it, do you think that that smaller, faster, and more tech-enabled firm is the best way to provide services as we go forward in the future?
Certainly that was kind of fit, as you described it, fit well with my thinking as well,
Mhm.
and part of the reason why I left Big Law to come to Redgrave. It's as really the kind of the preeminent e-discovery boutique in the country.
Mhm.
It had nothing really to do with my old firm. I spent my whole career at my old firm. I have many friends there and fond memories, but it really was kind of looking ahead and thinking about the future of litigation, white collar matters, regulatory responses in the context of increasing complexity with data, as well as um, technologies and the evolution of technologies to meet those complexities, whether it's companies using Gen AI, right, in their own business, and then that's creating what is essentially new evidence, and then potentially using technologies like Gen AI to digest them and to assess relevance and privilege and production criteria and the like. And that's just scratching the surface, right? Um, and and also my practice had just evolved over time where I wasn't really working on discovery matters for where my previous firm was trial counsel or white collar counsel. Instead, I was working as discovery counsel for other firms when the other firms were serving as trial counsel or white collar counsel. And that's all that Redgrave does, right? Redgrave is not trial counsel. Redgrave is not white collar counsel. They are eDiscovery counsel or discovery counsel. And so they fit and can really help specialize in that area. And then what it allows for clients and the services to clients is it allows expertise at all aspects of the spectrum of a matter, right? So you have your trial counsel that you want, um, but sometimes trial counsel doesn't have necessarily an expertise in eDiscovery or don't specialize in eDiscovery. We do, and so it allows us to partner with that counsel we call merits counsel, so that we can be leveraging our focus on kind of all aspects of the EDRM, and that allows trial counsel or white collar counsel to kind of focus on the substantive merits. And I do really see that continuing to evolve and in increasing demand as clients kind of recognize the need and the value because it just gets harder. Like our industry and our world, it gets harder every year, and it just is becoming increasingly difficult for the generalist third year associate at a big firm to really understand all the complexities of modern discovery, right? And also to be able to deal with it efficiently and effectively because there's a lot of techniques that may have worked fine 10, 15 years ago that now just you would be really going about things in an inefficient way if you were still leveraging those same techniques today.
You couldn't have teed me up better for my next question for you, Robert.
Yeah.
So I was fortunate for the last 5 years. I was doing once a year. I was teaching a course on eDiscovery and what to know about eDiscovery providers over at the University of Kansas Law School. Brandon does it for Tennessee, if I'm not mistaken. And one of the interesting things that I've said to law students, and Brandon, I think you've said the same, is that each year I seem to have progressively said, your class of graduating law students are living at a very interesting time and probably the most exciting time entering the law. And this last time I said it, I believed it more than ever. And when I listened to your last answer, Robert, I'm very curious from your perspective. So when you're talking about a 3L graduating this year, what are the three skills that you think that this graduating law student needs today that they didn't need 3 years ago or 5 years ago? What's going to make them really successful?
It's a really interesting question, and something I actually spoke to some law students about recently, where I came to a law school to give a presentation on Gen AI in the law. And what I said is that the graduating 3Ls are just going to be, starting to their law firms are going to be in the process of leveraging Gen AI, and, adopting tools, whether it's Harvey or other internal tools, but also starting to see it used in the cases more broadly. And I think that's really the first class that you can really say that about. Um, and what I told them, and it's not just me who said this, but other people have said this, that it's not that Gen AI is going to replace lawyers, but lawyers who use Gen AI are going to replace lawyers who don't, right? And so that to me is the most important thing, that one, the three L's really should focus on leveraging Gen AI in their day-to-day practice at wherever it is. Law firm, big law, small law firms, um, prosecuting offices, however it is, uh, that they should be really focusing on that and doing it effectively, and really figuring out, all the different ways that Gen AI could help them and make them more efficient and also make their work product better. And I think that is the biggest. And I think the second is really related to the first, but really be open to technology, and be open to change, uh, and kind of embrace it, because that's what we're going to have over the next several years, is just some really starting to see fundamental changes in how we go about this, and really be open to that part. And then the final thing is the exact opposite, which is all the technologies are going to be very important, increasingly important. But if you're going into a law firm, if you're going in-house, if you're going into an organization, you really need to still focus on the human relationships. And because it's the human relationships that will allow you to grow, find a good mentor, find multiple good mentors, right? It's really that connection that is irreplaceable and cannot be replaced by Gen AI. And so don't let that get lost in all the talk about new technologies.
Interesting. Well, as we close, Robert, one last question. Obviously, over the last several years, in your writing, your speaking, you've done a lot to really shape how a lot of attorneys and judges think about AI and e-discovery. If you had to pick one sort of uncomfortable truth about AI and its use in the legal practice that the profession still needs to face up to, hear, and deal with, what would be that one uncomfortable item that you would select?
That that it's not that it's not magic. It's math, right? It's very complicated math, um, but it's still math, and uh, and there's still a lot to this about the technology and Gen AI in particular that is still more of an art than a science, like how to leverage it and how to leverage it efficiently. And we see that, like if you just take your review protocol and you paste it in as a prompt, your results aren't going to be that good, right? That you really need to refine it and kind of step back and think about, well, okay, how could you write this in a way to make the Gen AI be as successful as it can be in analyzing the data set, um, and that you Gen AI can do a lot of things, but it's not perfect. And maybe this gets back to how we started the conversation. At the end of the day, you're still need and have to leverage and have to grow your own human expertise, human experience, and use that expertise and experience on your case. And it's Gen AI is like a supercharged tool, but it's still just a tool, and it responds differently to uh, how good the person is with the tool. And so it really rewards kind of an investment in time, but also like taking the results, and you still have to build the case. You have to figure out, well, which of the docs that it's turning back from you are going to be a good deposition exhibit or a good summary judgment exhibit, or what could play well before a jury, and like all of that, um, is still irreplaceable.
Well, Robert, we want to thank you. both Daniel and I and all the listeners of the NeLI Pod for your time and your insight today. It's truly been an honor to have you on the podcast, and we appreciate it.
Well, thanks again, guys. I appreciate you having me.
If you've enjoyed our discussion and want to learn more, don't forget to subscribe to our podcast on your favorite streaming platform. We're here to help you stay on top of the latest trends and developments in eDiscovery.
We'd love to hear your thoughts and questions about today's topic. Reach out to us via our social media channels or email us directly. Your feedback makes our program stronger and more attuned to the topics you care about in the world of legal technology.
Remember, all the resources and insights shared today are aimed at enhancing your practice and understanding of eDiscovery.
Join us next time on NeLI Pod as we continue to bring you expert knowledge and lively discussions. Until then, keep innovating, keep discovering, and keep pushing the boundaries of legal technology. Thank you for listening, and we'll see you next time.